5 seconds to go. Start. More than a decade back, this court had expressed serious concern despite its repeated pronouncements in regard to the High Court's ignoring the availability of statutory remedies under the RDBFI Act and the SURFACE Act and exercise of jurisdiction under Article 226 of the Constitution. Even after the decision of this court in Satyavati Tandon, United Bank of India versus Satyavati Tandon 2010 8 SCC 110 2010 3 SCC Civil 260, it appears that the High Courts have continued to exercise its writ jurisdiction under Article 226, ignoring the statutory remedies under the RDBFI Act and the SURFACE Act. It can thus be seen that it is more than a settled legal position of law that in such matters the High Court should not entertain a petition under Article 226 of the Constitution, particularly when an alternative statutory remedy is available. The only reasoning that could be seen from the impugned order given by the learned division bench of the High Court is as under. It is true that under Section 18 of the SURFACE Act, petitioner has the alternative remedy against the impugned order by filing appeal before the appellate tribunal. However, having regard to the fact that the writ petition is pending before this court for quite some time, and also considering the fact that if the impugned order is allowed to stand, petitioner would be left without a remedy to ventilate his grievance, we deem it fit and proper not to non-suit the petitioner on the ground of not availing the alternative remedy. Section 17 of the SURFACE Act provides that any person, including a borrower who is aggrieved by the action of secured creditor under Section 13(4) of the SURFACE Act, may file an application thereunder. Supreme Court has held time and again that the tribunal exercises wide jurisdiction under Section 17 of the SURFACE Act, even to the extent of setting aside an auction sale. In the instant case, we are consciously not referring to the merit of the case. All that we are concerned is whether, for whatever reason, a person who is aggrieved in law should be left remediless. In the instant case, petitioner had invoked his remedy by filing securitization application under subsection 1 of Section 17 of the SURFACE Act. The application was pending for 3 years before the tribunal. From the docket order dated 21st September 2020, we find that a junior counsel appearing on behalf of the petitioner had reported that the matter was settled out of court and therefore leave was sought for withdrawing the securitization application, which was accordingly granted. When the settlement did not materialize, petitioner went back to the tribunal for revival of the securitization application, which was however dismissed on the ground that version of the petition did not deserve acceptance. On thorough consideration of the matter, we are of the view that dismissal of the miscellaneous application of the petitioner by the tribunal does not appear to be justified, though subsequent developments may have a bearing on the grant of ultimate relief to a litigant, but the same by itself cannot denude the adjudicating authority of its power to adjudicate the grievance raised by the aggrieved person which it otherwise possesses. Stop.